This is a continuation of our review of BLLE Chapter 9, The Agreement. In this part, we review how long an offer is good for and how an offer is accepted, who can accept it, and when acceptance is effective. The next way an offer may expire is by lapse of time if the offer expressly states a time limit, whether orally or in writing. If there is no express time limit in the offer, then the common law rule is that the offer lasts a reasonable time, which is a factual question, i.e., a question of fact. Also, the more risk to the seller, the shorter the period of a reasonable time. Further, under the Restatement Second, Section 41, if an offer is made by mail, then it is seasonably or timely accepted if an acceptance is mailed at any time before midnight on the day on which the offer is received. Under the common law and the UCC, the offeree must notify the offeror that they have begun to perform the terms of the contract. Absent that notification, the offeror may, after a reasonable time, treat the offer as having been lapsed. Death or insanity of a person or destruction of an essential term of an offer also terminates the offer. This termination is by operation of law. So if either of the parties dies or is adjudicated insane prior to the acceptance of the offer, then the offer is effectively terminated. It is not necessary that the death or the insanity be communicated to the other party. But under the second statement of contracts in Section 48, if the offeror has a supervening mental incapacity without being adjudicated, then this will only terminate the offer if the offeree is aware of the offeror's incapacity. Another note, if we are dealing with an irrevocable offer, like an option contract under common law, then the offer will not terminate in this way. And if there is a statute that makes the subject matter of the contract unlawful, then that also operates as a termination of the offer if the statute takes effect after the offer was made. So, for example, an offer to sell a quantity of herbal weight loss supplements will terminate if the FDA outlaws the sale of such supplements. Now that we have covered offer, what about acceptance? You know, the other part of mutual assent. Acceptance is defined in the restatement and in the UCC in different ways that take a similar meaning. Under the restatement approach, acceptance is defined as a manifestation of assent to the terms thereof made by the offeree in a manner invited or required by the offer, wherein the offeree may accept with either a promise or performance. Under the UCC approach, acceptance may be made in any reasonable way unless the offer requires that it be accepted in a particular way. What each of these perspectives illustrate is that the offeror is the master of the offer, meaning that acceptance is defined and limited by the offeror in the offer. The offeree must accept the offer the way the offeror says. Even more, only the offeree may accept the offeror's offer. The offeree, i.e. the person to whom the offer is addressed or directed, is generally the only person who has the power of acceptance. It does not matter if someone else is providing consideration. Keep in mind that the offeree may be a person or group of people. An offeree also has the power of acceptance if they are a member of a class to which an offer has been directed. If the offer is made to the general public, then the general public, meaning anyone for that matter, is the offeree. If the offer requests performance from an unlimited number of persons, then anyone who received a communication of the offer or had knowledge of the offer is an offeree for these purposes. When one of those offerees accepts in that instance, then their acceptance cuts off the power of acceptance of all the other offerees. So for example, if offeror Jesus promises to sell Tiffany his car if Tiffany's dad will promise to pay him $3,500, then the offeree is actually Tiffany's dad, not Tiffany. Technically, Tiffany cannot accept Jesus's offer because she's not the offeree. Only her dad can accept the offer. When acceptance is effective follows a number of general rules enumerated here, depending on how it's communicated. This is an important concept because offer, when coupled with acceptance and consideration, will form a binding and enforceable contract. If acceptance is not effective, then there will be no contract formed. If the parties are on the phone and the offeror communicates an offer, then the offeree's acceptance is effective instantaneously when communicated. Next, if the offeror makes a stipulation as to how the offeree may accept, or otherwise uses a stipulated mode, then acceptance is effective when it is sent. So, if the offeror states that an offer can be accepted only through a specified mode, then that mode must be used to effectuate acceptance, because the offeror is the master of the offer. However, if the offeror does not specify a mode, then acceptance is effective when it is transmitted, as long as the offeree uses a reasonable method of acceptance. Keep in mind that the offeree may use the same methods of acceptance as the offeror used to communicate the offer, including any industry custom means. Next, under the mailbox rule, acceptance is effective when it is mailed, regardless of what method being used to transmit the offer. Acceptance by mail or similar means creates a contract at the moment of dispatch, provided that the mail is properly addressed and stamped. This rule is applicable even though the offeror is not aware that the offeree mailed acceptance. It also doesn't matter if the letter gets lost on the way and doesn't get to the offeror. If the offeree mails acceptance, then acceptance is effective when it is sent. There are a few exceptions to the mailbox rule, though. So if the offer stipulates that acceptance is not effective until it is received, then that's because the offeror is the master of the offer. Or if we are dealing with an option contract in which acceptance is effective only upon receipt, then under the mailbox rule exceptions, acceptance is effective when it is received. In the same vein as the mailbox rule is the rule that acceptance outruns rejection. Under this rule, if the offeree sends a rejection and they later send a superseding acceptance, maybe because they changed their mind, then whichever one gets to the offeror first is the one that's effective, and the mailbox rule will not apply. So if acceptance gets there first, i.e. outruns rejection, then acceptance will be effective and a contract will be formed. But if the offeree sends acceptance and then later sends a rejection, then the mailbox rule will apply and a contract is created when acceptance is dispatched. Note that if the offeror receives the rejection first and later changes their position in reliance on that rejection, then the offeree will be stopped from enforcing the contract despite the mailbox rule to avoid unjust results. So what happens if the offeror revokes? Think about it like this. Acceptance is effective when it is sent. Rejection or revocation is effective when it is received. So under the mailbox rule, if the offeree sends acceptance before he receives revocation from the offeror, then a contract is formed. It doesn't matter if acceptance is sent after the revocation and received after the revocation. Next, under the Uniform Electronic Transmissions Act, electronic communications, including offer and acceptance, generally follow the same rules and are not denied legal effect or enforceability solely because they are in electronic form. If a law requires a record to be in writing, then the electronic record satisfies that law. Also, if a law requires a signature, then an e-signature satisfies the law. And lastly, as a general rule, silence does not operate as acceptance. Silence may take the form of a failure to respond and is ineffective acceptance. However, there is a notable exception to that general rule under the Restatement Second of Contracts in Section 69. Although the offeree cannot be forced to speak under penalty of having their silence be treated as acceptance, if the offeree silently takes the offeror's benefits, then their silence will operate as acceptance. That means that if the offeree avails himself of the services proffered by the offeror, when the offeree could have rejected, and the offeree had reason to know that the offeror expected to get paid, then that conduct operates as acceptance of the offer. Also, if the offer states that the offeree may accept without responding to the offer, and the offeree intends to accept it by remaining silent, then that conduct also operates as acceptance too. Further, if the offeree and the offeror have had a previous dealing, or if there are trade practices known to both parties that allow for silence as acceptance, then silence may also operate as acceptance because those facts create commercially reasonable expectations in the mind of the offeror that silence may operate as acceptance. There, if the offeree intends not to accept, then it is reasonable for the offeror to expect the offeree to say that they do not accept. This concludes our review of BLLE Chapter 9, The Agreement. If you have any questions, please feel free to send me a message in Canvas or just ask me after class.